Well, good afternoon, Michiganders. It is Tuesday, September 13th, 2022, almost halfway through the month of September already. And of course, this is Tuesday with Tom, Michigan's only weekly internet show where we do answer your questions about estate planning and estate settlement in Michigan, and we don't send you a bill. As always, I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and ambassador for all things good in this great state of Michigan. Welcome to today's program. Well, a brief recap. Last week's episode, why you should file a property transfer affidavit with your deed. If you're looking at transferring real estate in the state of Michigan, maybe you're transferring it into your living trust, or you're transferring it to a family member, whatever it happens to be, you should consider and review and listen to last week's episode where I talk about the importance of filing a property transfer affidavit with the assessor's office once you go ahead and have that deed recorded. Today's show, should you use a DST as your 1031 like-kind exchange? Should you use a DST as your 1031 like-kind exchange? But please remember, what I'm about to discuss during this program is for educational purposes only. It is not intended to be legal or financial advice or tax advice to you. You need to work with your attorney and your tax advisor and your financial advisor to determine what is appropriate for you and your estate plan. Should you use a DST as your 1031 like-kind exchange? Well, let's just start with, because I'm going to assume that you're somewhat familiar with the concept of a 1031 exchange. That's where you've got real estate property, perhaps you've depreciated it fully, or it's increased substantially in value. You're looking at, if I sell this property, I'm going to incur a significant capital gains tax that's going to have to be paid. Maybe there's an option that might be available to me where I exchange this real estate for a like-kind real estate, and by doing that, I defer the capital gains on the real estate because it's a qualified like-kind exchange under the IRS code. And at the same time, one of the things I'm doing is preserving stepped-up basis in that property for my children, assuming that I'm going to be holding on to that new like-kind property until the time of my death. So some time frames, if you will, and considerations in general for that 1031 like-kind exchange. I'm going to talk briefly two time frames for what's the most common, which is called a delayed exchange, and then for another concept which is known as a reverse exchange. But with a delayed exchange, here's what you're essentially doing. You're going to complete the sale of your real estate. When you do that, though, the proceeds from the sale have to be given to what's called a qualified intermediary. That's going to be somebody who's going to hold on to those proceeds and essentially can't have any other connection with you. There's requirements for a qualified intermediary, but they're going to hold on to those proceeds as a starting point. Then, from the time you sell that property, you have 45 days to identify the replacement property. And I'm not going to get involved here in all the qualifications for what is a replacement property, but the time frame is you've got 45 days from the sale to identify that replacement property. And then you have 180 days after you've completed the sale in which to purchase the replacement property. So you're going to sell your property. You're going to give the proceeds to a qualified intermediary. Within 45 days of the sale, you're going to identify the replacement property. And then within 180 days of the sale, you're going to complete the purchase of the replacement property. And if you qualify for all of those, if you accomplish all of those steps and you qualify for the replacement property, etc., you have completed your like-kind exchange. And essentially, you're not going to have to then pay the capital gains at that time. And down the road, if you still have that property, you've reserved the stepped-up basis for your children. Now, a reverse exchange. A reverse exchange works a little bit differently. Essentially, with a reverse exchange, you are buying the replacement property before you sell your existing property. So, you purchase the replacement property. That property, though, when you purchase it, now has to be held by what is known as an exchange accommodation title holder. That is somebody that's going to hold on to the title to that property of the property that you just purchased. Then you have 45 days to identify the replacement property, to identify what property you're going to replace it with. And you're going to have 180 days to complete the sale. So similar to the delayed exchange, you've got that same 45 days to identify the replacement property. And then you've got 180 days to complete the sale. But when the sale is completed, that exchange accommodation title holder is essentially purchasing the property and then transferring the property to you. So, similar time frames that you're looking at, but in the delayed exchange, you're going to sell your property and then go find a replacement. In the reverse exchange, you're going to already purchase the exchange property before you've actually sold the property that you have. The problem can be identifying replacement property, given the market, at least most recently, where properties were selling so quickly. It became very difficult because property came onto the market and was gone before you knew it. And so sometimes that 45 days presents a problem for you in identifying the replacement property. And it can be a problem in many cases to complete the purchase of that replacement property within 180 days. And another consideration, let's say that you have rental properties and you're looking at selling that rental property, and now your like-kind exchanges to other rental properties, and maybe you're sitting there saying, you know what, I really don't want to be a landlord anymore. I don't want to incur the capital gains tax for the sale, but I really don't want to exchange this for other rental properties where I'm still going to have to be a landlord. So, what is a possible solution? A possible solution for you is what's known as a Delaware Statutory Trust. That's going to be a trust that's created under Delaware law. Now, don't worry about the fact that you're in Michigan. You can have an interest in a Delaware Statutory Trust even if you're in the state of Michigan. But the idea with the Delaware Statutory Trust is this. You, rather than going out and finding replacement property, are going to purchase an interest in this Delaware Statutory Trust. This Delaware Statutory Trust, which obviously has to already be created, it has to qualify under the IRS code, etc. It owns real estate. Bottom line, Delaware Statutory Trust is going to own real estate. It might be commercial properties such as, maybe malls or whatever it happens to be, but it's going to already own what otherwise would be considered your qualified replacement property. And so you are going to take the proceeds from your sale of your property, and you're now going to purchase an interest in this DST. You have what's called a sponsor of the DST. That's essentially who creates it and runs it and manages it. you will be a beneficiary. Just like a regular trust has a beneficiary, you are purchasing, if you will, an interest in this DST, and you will now have a beneficiary interest in that DST. That, because it's a Delaware Statutory Trust, because it's already a qualified Delaware Statutory Trust, that completes your obligations of purchasing replacement property within that 180 days. And there are many DSTs out there already just looking for people to invest in. Obviously, you need to do some checking, and your accountant, your tax advisors need to do some checking. Your financial advisor might already be familiar with various DSTs that are available out there, but you're going to have to explore them to see what's appropriate for you. What are they investing in? What's their track record? What's the sponsor's track record? What sort of return are they providing? Because normally then what's really happening is your beneficiary interest in that DST is going to pay you a stream of income. So you're taking this real estate that you're actively managing, turning it into a stream of income for yourself. Now, there's going to be some general restrictions on who can be a beneficiary, who can purchase an interest in a DST. You're going to have to be, if you're not already a financial advisor, you're just a normal individual who's accumulated an estate, you have to be what the IRS considers an accredited investor. And essentially what that means is you have to have a net worth in excess of $1 million, excluding your primary residence, income over $200,000 or $300,000 with a spouse in each of the 2 previous years, and reasonably expect the same for the current year. So you have to be, this is not for everybody, it's for what the IRS considers an experienced investor. Now, obviously, your advisor, your tax advisor, your financial advisor will be able to make determinations with you whether or not you qualify as an accredited investor. But if you do, then you have the ability to buy into one of these DSTs. Another consideration, a DST is essentially sold as a security. So you can't just buy it from anybody. You're going to have to buy it from a registered broker or a registered investment advisor. Because the IRS looks upon it as being a security, there are those restrictions on who can actually sell it to you, and they want to make sure that you are what they considered a sophisticated investor and know what you're getting into. What does it accomplish for you? Aside from qualifying as a 1031 like-kind exchange, what does the DST provide to you? Well, one of the things I already mentioned is perhaps you want to get out of active property management. You want the income to be coming in. You want to continue to be invested in property. Maybe you want to change the type of, maybe you're invested in your farmland and you're going to be getting out of the farming business perhaps, but you still want to be invested in real estate, and you have problems relative to capital gains if you went out and sold the farmland that you have. Turning it into a different type of real estate through a DST might provide that as an opportunity for you, and you're now not going to be involved in actively managing it. You're creating a passive income streams to yourself. Another important consideration for some of you, though, is you are limiting your liability. Take that farmland that you already have, or maybe that apartment building that you already have, or the real estate that you already have. Somebody gets hurt on that real estate, unless you have other plans in place. You're the owner of the real estate. You are subject to liability for claims that might be made by someone who was hurt on that real estate. If you invest in a DST, you don't have that liability. You have no personal liability for the assets that are held in the DST. So for some people, adding that limited liability protection on top of the other considerations that they have is going to be a plus, if you will, that might cause you to go down that road. Now, there's going to be disadvantages. Anything has advantages, disadvantages. A couple of the disadvantages that you need to think about with the DST is, one, it's pretty, you've got a liquidity issue with the DST, because normally you're going to have to hold on to that for probably 5 or 10 years before you're going to be able to get out of it off. Normally, the DST is set up and it's buying, let's say, a particular commercial property, and once it has all the investors in that commercial property, everybody that's invested in it is basically holding on to their interest in that in that TST until the commercial property perhaps might be sold one day. So there is an illiquidity issue. It's not like stock that you can just go out on a stock exchange and sell it. And maybe you're somebody that really wants to be involved in the day-to-day operation of the real estate. You don't get that with the DST. You're simply an investor. You get a stream of income, and that's what you're getting from it. But for those who have real estate that, if they sell it today, are going to have a significant capital gains problem, want to avoid that capital gains problem, still be involved in owning real estate, and now have a stream of passive income from the real estate, and doesn't want to go through the whole process themselves of finding replacement property, et cetera, a DST might be exactly what you are looking for. Now, some things to think about too. You could, let's say you've got 4 kids, as an example, and you've got a significant ownership in real estate now, and maybe your estate plan is that you want the property PD divided between the 4 children at the time of your death. You could, it might make sense in some circumstances, to actually have multiple DSTs, set up 4 DSTs, having one DST designated for each of your children. Essentially what that does for you is, upon your death, it takes away 4 of the kids all having to agree, or a trustee having to deal with all 4 of the kids in what's going to happen with the real estate. You've already done that in advance, where you've converted the existing real estate into an ownership interest in other real estate that, again, is going to have a stream of income for your children. So you can have multiple. It's not only one. Under some circumstances, having multiple DSTs might be a prudent piece of your estate planning puzzle. Now, because it's a trust, it's a Delaware Statutory Trust, the terms of the trust are going to control some of the issues concerning the trust. One of those is, question, can the interest that you're purchasing in the DST be owned by your living trust? You perhaps have a living trust that you've created as your estate planning tool. You've created in part that trust maybe to avoid probate. You understand that the importance of taking assets that you own and put them into that living trust so that upon your death, they don't have to go through probate. You're going to have the terms of the DST understood as to whether or not your interest in the DST can be owned by your living trust. The IRS says it can, but again, you could end up with a DST that doesn't allow that to happen. An alternative might be, particularly here in the, depending upon, we're talking about in the state of Michigan, Michigan allows transfer on death designations now in many, many assets. And it might be that your DST is set up to allow a TOD to the beneficiary. So maybe it's not going to permit you to put it in your living trust, but perhaps it's going to permit you to have TOD beneficiaries at the time of your death, and you're going to accomplish that probate avoidance through the TOD. So if you're looking at giving consideration to a 1031 like-kind exchange, I encourage you, talk to your tax advisor, talk to your investment advisor about whether or not a Delaware Statutory Trust is going to make sense for you as part and parcel of your overall tax planning strategy, financial planning strategies. Of course, Amanda and I would be happy to work with you and your financial advisor and your tax advisor if you're looking at purchasing a DST and want it as a part of your overall estate plan. We'd be happy to work with you and your advisors in doing that. Maybe a DST isn't going to be right for you. Maybe you're not looking at a 1031 exchange, but whatever it happens, the circumstances happen to be, Amanda and I would be honored to have the opportunity to talk to you about how we might be able to be of assistance to you in protecting your loved ones by either putting together an estate plan for you or amending a plan that you already have or assisting you in settling a loved one's estate. So I invite you, head on over to doylawpc.com. There you're going to find our virtual office. Click on the virtual office tab. You're going to find information there. And if you're a prospective client, how it is we can go about helping you. You can schedule an appointment online. There's some information that you can download. We provide you with the ability to send that information to us in an electronic format or to upload that information, so we'll have it when we consult with you. If you're an existing client, not only can we do that, but under the existing client tab, you're going to find the update my plan option. Essentially what that is you're already a client of Doyle Law PC, and maybe you're saying, you know what, I just want to change the person that I've named as my patient advocate in my healthcare power of attorney. You fill out the form, send that information to us, we'll look at that, and we will then get back to you on what's it going to take to accomplish the change that you're looking at making. And we might be able to accomplish all of that without the need to actually have another consultation in order to complete that change for you. Of course, too, whether you're an existing client or a new client, at the website we have our legal store. And through the legal store, you have the ability to purchase individual documents. Maybe you need a new certificate of trust because you're looking at selling real estate and the title company is saying, hey, you need a new certificate of trust in order to do that. Several individual documents are available through the legal store that can be ordered online from us as well. Well, I think that's going to be it for today's show. As always, if you have a comment about the program, perhaps a topic that you'd like to have me discuss or questions that you'd like to have answered, please send me an email. Many of the topics that we talk about in the program come from questions of listeners like you. So send us your questions and we'll see if we can't answer those as part of the program. But you can send me an email. That would be tom@tuesdaywithtom.com. Or mail me a postcard, Tom Doyle, P.O. Box 3752, Grand Rapids, Michigan 49501. And of course, you can always follow us on Facebook and Twitter. That is again at Tuesday with Tom. Follow the office, please, on Facebook and Twitter as well. That would be at Doyle Law PC. And please invite your friends and family to follow this podcast and the office as well about information that's going on in relative to estate planning or estate settlement in the state of Michigan that might be helpful to them as well. Of course, the program is available as a podcast on Apple Podcast, on Spotify, on Google Podcast, on iHeartRadio, on Spreaker, on many, many other podcast services. It is likely available on any podcast service that you are listening to. And you have a smart speaker at phone. You can always ask your smart speaker to play Tuesday with Tom. Thank you again for spending some of your Tuesday afternoon with us today. As always, I hope that you have an awesome day and an awesome week in Michigan. Stay safe now. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.